Hello, everyone. This is Sercan. I'm the Secretary General and one of the founding members of SCL Turkey. So welcome to this new episode of SCL Talks. Our guest in this episode is Nick Sekulic from Ankara Consulting. Nick is a managing director in the Construction Disputes and Advisory Division of Ankara. Nick will be giving us information on expert evidence in construction disputes from an international perspective with his recent experience. So, Nick, the floor is yours.
Thank you, Sercan. Great to see you again, and greetings to the members of SCL Turkey and any other guests that might be privy to watching this video. I was really inspired to give this talk by my recent experience in two separate international arbitration proceedings, which were seated in the same place. They were subject to the rules of the same jurisdiction, and they were administered by the same institution. Nonetheless, my experience led me to observe a number of very interesting characteristics regarding the differences in treatment of expert evidence. It is common that complex international construction disputes, whether by way of international arbitrations or dispute advisory boards, do not only revolve around issues of law and contractual analysis. In practice, often, if not always, forensic analysis of large volumes of technical data will be required, and typically the necessary analysis will be carried by discipline experts. And each party may appoint its own experts or experts, to include quantum experts, which can be quantity surveyors or cost engineers, or at times accountants, depending on the point of origin, experts for delay, which can be planners, programmers, or project managers, or cost engineers, or at times quantity surveyors, or technical engineering or design experts to deal with issues of defective design, materials or workmanship, changes to design or design standards, or negligence if that is an issue in dispute. So it is clear that many experts may be involved in a single dispute, and those experts will not only be covering different disciplines, but may often come from different legal systems and traditions. And therefore, they may be used to different set of legal and professional rules, requirements, duties, methodologies, and consequently diverging levels of applied rigor in their work and provision of expert opinion. By way of example, in some common law jurisdictions, role and duties of experts are highly regulated, with very clear and strict rules, guidelines, and emphasis placed on experts' role in assisting a forum, court, or the arbitral tribunal, with emphasis which is placed on the overriding duty of independence in assistance to the tribunal and not to the paying client, and obligations to follow clear delineations between matters of law, issues of fact, and those subjects that are to be addressed by way of expert opinion. On the other hand, in civil law jurisdictions, the rules relating to provision of expert evidence at times may not be as strict or detailed. There often may be a single forum appointed expert, i.e. a single expert that is appointed by a court or the tribunal, whose role and expectation may be to provide opinions on culpability and or provide decisions on certain discrete issues. The forum itself then can choose whether to adopt the expert evidence and to what extent it is relevant. And when that happens, the expert opinion practically forms a decision on the issue in dispute. In addition, in international construction disputes, forums may be composed of members coming from different legal traditions. These differences can manifest themselves in conduct of dispute resolution procedure and its treatment of expert evidence and testimony. The conduct of international dispute resolution procedures may also be affected by origins of the parties' representations, because they will have their own experiences and expectations in terms of how to conduct proceedings. With all that in mind, it is clear that there is quite a wide scope for mix-up that exists in international arbitrations when it comes to expert evidence. And specifically and procedures more generally. Whether that mix-up originates in different cultures of experts, tribunals, or party representation, or all of the above, as the case may be. This can often lead to mismatch in expert evidence, which fuels arguments rather than provides assistance to the forum.
Okay, so Nick, could you tell us a bit more about your recent experience in this regard?
Yes, very interesting, Serjan. I've had a first experience of these diverging procedural cultures very recently, which is visibly illustrated differences in approaches to provision of expert evidence specifically. Over a period of little under 4 weeks, I've attended and provided evidence in 2 international arbitral hearings, both of which were seated in the same seat and administered by the same institution. In both matters, there were party-appointed discipline experts, and both matters required delay and quantum expert witnesses. Difference? Well, the first tribunal was composed entirely of members coming from a single civil law jurisdiction. Both parties' representations came from the same jurisdictions as the tribunal members. The state of origin of parties was different, but they both came from civil law traditions. So I'll refer to this tribunal as the civil law tribunal. The second tribunal, on the other hand, was composed of members coming from common law systems, although not all tribunal members were from the same jurisdiction, or they didn't come from the same state. Both parties came from civil law system. This is quite interesting. But both parties had representation from common law lawyers. The parties came from different states, but their representations came from the common law tradition and from a single jurisdiction. The common law tribunal testing of expert evidence included taking of oath, which was followed by affirmation of expert reports, including the signature under the statement of truth and expert declaration, quite formal procedure, which is very familiar, particularly those that practice in jurisdiction of England and Wales. This was followed by a short presentation by a discipline expert, which was then followed by a lengthy and vigorous cross-examination by counsel, implementation of PERDA. PERDA, for those that may not be familiar with that term, means rules on seclusion of witnesses whilst providing evidence, and effectively bans the witness from communicating with anyone on issues related to the proceedings whilst under oath. This was then followed by questions from the tribunal, and it finished with a short re-examination on points arising by or the experts on site. On the other hand, the civil law tribunal did not require taking of oath. In fact, this was not required from witnesses of fact either. It did not require affirmation of expert reports, so the whole procedure was significantly less formal. The expert testimony opened with a lengthy presentation. It could be 3+ hours. Certain experts took up to 6 hours to effectively repeat their expert reports to the tribunal. This was then followed by examination in chief, examination by experts' own instructing lawyers, which was then followed by a brief opportunity for the other side to cross-examine the expert, but which was nothing like what you'd encounter in common law proceedings. And finally finished off with a very brief re-examination from the experts' instructing side. There was no imposition of PERDA, and experts were completely allowed to communicate with their legal teams at all times and during the breaks.
So what other differences have you observed between these two?
There's very interesting and quite significant sentient difference, which was that when appearing before the common law tribunal, challenges to expert opinion in cross-examination were underpinned by references to testimonies of witnesses of fact, which were given earlier in the proceedings, as well by reference to the other experts' testimony, which was provided earlier in those proceedings. In effect, each expert witness was expected to follow the procedure of the proceedings from the beginning to the end, and to be familiar with all other relevant testimonies, and effectively be prepared to revise its views as appropriate. I mean, the underlying logic, as I understand it, of this process is to ensure that expert opinions generally aligned with factual background and other expert technical opinion as it may be relevant. And where those alignment cannot be achieved, then it very visibly then identifies any divergence or idiosyncrasy in opinion by a single expert. However, before the civil law forum, expert witnesses were not allowed to follow testimony of either factual or other expert witnesses. In fact, you are not allowed, one was not allowed to follow proceedings at all. And as I understand it, the logic of that approach is to allow expert to express unadulterated, pure opinion, which is not swayed by views of others. Once the testimony is given, the tribunal then decides if and to what extent that expert opinion may be relevant to the case. So in this particular instances, it's really interesting. The delay, speaking specifically of my role in these proceedings and the other my counterparts, if you like, delay experts engaged in the case which was heard before the common law tribunal were very similar in their approaches, because they both came from common law jurisdictions and basically followed a similar set of principles, as was, I suppose, expected, really. However, when it came to the experts before civil law tribunal, the approaches were markedly different. Whilst one party expert took approach that would be more suitable to rigors and demands of common law jurisdiction, the other expert was a little more relaxed in its approach, which is probably to be expected given the cultural differences, and probably approach this with less independence that would normally be expected. However, the most interesting point is that, quite counterintuitively, these diverging approaches did not cause many practical difficulties in this particular instance. And this is, I think, because the civil law tribunal did not require procedure that we in common law jurisdictions refer to as a joint expert process, where experts are required to meet and attempt to align their positions, and or where they cannot align, clearly identify the points of differences. Because this kind of joint expert process was not really required by a civil law tribunal, there was no scope for direct interaction between the two experts. And I think that helped, because I cannot see how it would be very difficult, let's say, to make the joint expert process work, given the divergences in approach, as you can see. I mean, overall, these examples, whilst in this particular instance did not perhaps cause as many problems as they could, but they indicate on the one hand, the differences where by the approaches, differing approaches to expert testimony could cause quite a lot of practical issues. On a more positive note, they also indicate what's probably really quite important for international arbitral proceedings, that they illustrate a great degree of flexibility and ability for party autonomy to manifest itself by significantly defining and setting parameters for the procedures to be applied in any given case, which is probably of essential importance to international arbitral proceedings.
I see. Well, thank you, Nick, for telling us about your recent on-hand experience about that expert testimony issues in two separate, let's say, grounds, basically. So, and thank you for that peek in your experience in that field.
My pleasure, and I hope it will be of assistance to your members.
Thank you very much again. So, everyone, thank you for watching. So, I would like to thank you all on behalf of SCL Turkey, and we hope to see you again in our next episode. Thank you very much.